SJC-12564, Commonwealth v. Dennis Jones.
Good morning, and may it please the Court. Gabriel Pell, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. The Commonwealth is asking the Court to reverse the orders denying its GELF-GAP motions, and in the process to confirm and clarify the evidentiary standards and procedural protocols applicable to motions for compelled production of passcodes to digital evidence. Although this Court applied the foregone conclusion doctrine to compelled decryption of computer files in Commonwealth v. GELF-GAT, it did not further quantify the level of proof or level of certainty the Commonwealth needed to establish in order to meet its burden.
Let me ask you here. We're only talking about the part of it having to do with the whether he owned or had control over the telephone, because the judge made findings as to the other part already that were in your favor, were they not?
I think what the specific question before us is very narrow, and whether or not he knew the passcode to the phone. With respect to the other findings that Justice Krupp made in his initial decision, as we noted in both our renewed motion and this brief, Justice Krupp made findings with respect to the relevance of the content of the phone that we submit is the inappropriate question to be asking. The contents of the phone are irrelevant. We do, however, believe...
Relevant on a GELF-GAT?
Absolutely, Your Honor.
Okay.
And I would appreciate the opportunity to explain why.
Okay.
We can go to that. So the foregone conclusion question asks whether the evidence that we're compelling is already known to the Commonwealth. And in the context of compelled production of the passcode, the very limited piece of testimony that we're getting that's inherent in the act of production is a simple statement, I know the passcode. It's not, I'm the exclusive user of the phone. It's not, I'm the regular user of the phone. And it's certainly not, I know the contents of the phone. It's just, I know the passcode, where that's what we're seeking to compel. So the Commonwealth's objective is to establish that we know already that the suspect, the target, knows the passcode. And
So let me ask you about that. If this were in a federal court, you'd essentially be saying this is essentially requesting active production immunity. That I'm going to essentially immunize the fact that you tell me the PIN in order to produce the documents, because it doesn't do any good for you to produce the documents if we can't open them.
I do recognize that immunity and foregone conclusion are to some extent two sides of the same coin, but they are a separate analysis. And in the first instance, this is a question of whether or not the defendant can actually claim a Fifth Amendment right in the first place. And
Well, he certainly has a Fifth Amendment right.
He has a Fifth Amendment right when the evidence to be compelled is incriminating, and
Which it would be.
It may or may not be. I think that's...
Depending on what is in there.
Right. That's one of the interesting points that Professor Kerr points out in his amicus brief, is that the knowledge of the passcode itself, it has to be at least a little incriminating, or there's no Fifth Amendment right whatsoever, but it...
You wouldn't ask for it if you were not hoping they would be incriminating.
Again, I think that we have to focus very precisely on what it is we're asking for. We're asking for the passcode.
Right.
We don't expect the passcode itself to be incriminating. In fact, the passcode itself is likely not entitled to any Fifth Amendment protection. Number one, it's unlikely to be incriminating. But even if the passcode is, I am a pimp, in all caps, it's still not entitled to Fifth Amendment protection because we didn't compel the defendant to choose that passcode. In the analogy to the original document production cases in which the foregone conclusion arises, the content of the documents is not entitled to Fifth Amendment protection. It's only the implicit testimony that they exist, I possess them, and they're authentic. So the passcode itself is akin to the content of those documents.
Okay, but the fact that he can open that phone says something about his control of that phone.
And again, control of the phone is irrelevant from our perspective.
It's not irrelevant, because if it's not his phone, then you have to authenticate it to be his, and you have to not only authenticate it in terms of getting it into evidence, but you would arguably want to establish the fact that that is his phone, and therefore the statements are his as opposed to somebody else's.
That's correct. So let me be more precise. That is irrelevant to us from the perspective of the Fifth Amendment Article 12 GELF-GAP motion, whether he controls it. Because you can know the passcode to a phone that you don't control. Your significant other's phone, Professor Kerr is an example of a sibling's phone. So from the Fifth Amendment perspective, all we want to know is that he knows the passcode. And we're not actually hoping for that to be incriminating in and of itself, because under Commonwealth versus Burgess and footnote 16 to Gelfgott itself, we can't put that in evidence, even if we want to.
But if it truly is the other side of the coin of immunity, the standard for immunity, if somebody is to give immunized testimony of any sort, whether it be active production or otherwise, and then the Commonwealth or the government seeks to prosecute that person, you would have to go through a taint hearing, and the burden on the government would be to prove beyond a reasonable doubt that nothing arising from that immunized testimony was in any way used by the government. Correct?
I mean, I think it would depend on whether or not it was transactional immunity, active production.
Transactional, the ball game is over because you can't prosecute him, period. It's only, we get into Oliver North world where they fail to prove
But I think that's
taint.
I think that's why, although the doctrines are to some extent related, the foregone conclusion doctrine is different, because we don't ask about what we derive from it. We just ask whether the limited testimony we're seeking to produce, which is that he knows the passcode, is already known to us.
Right.
And if it is, that's where it ends, and we compel production
If
of the
it
passcode.
is, then you can show beyond a reasonable doubt that you learned nothing that you didn't already know because you already knew it beyond a reasonable doubt.
Well, we don't believe that the reasonable doubt standard is the appropriate one in this case.
That's my question. So if once you compel him to open that phone, then you do know beyond a reasonable doubt that he has access to that phone.
The foregone conclusion doctrine requires that we show to a foregone conclusion before he opens the phone that we already know that he has the ability to do it.
And the question is what it means to already know.
And then what it means is what's the applicable standard. And the Commonwealth's contention, as at least one federal district court judge has already found, is that it should be...
No, it's only one judge, and it was in a set of facts completely unlike this.
It was a different set of facts, but I think here we're talking about what the applicable standard would be in any case that arises.
But he had enough facts to do it beyond a reasonable doubt, although he chose to say it was clear and convincing evidence.
We're talking about Judge Breyer in United States versus Spencer, correct?
Yes.
And I think what he says, and we agree, is that clear and convincing evidence strikes the appropriate balance. It strikes the appropriate balance between the jealously guarded rights against self-incrimination in Massachusetts under both the Fifth Amendment and Article 12 on the one hand, and the Commonwealth's right to every person's evidence on the other hand, particularly here where that evidence is going to be used to facilitate execution of a previously
But at
search
least
warrant.
6 United States circuit courts have adopted something higher than clear and convincing evidence. They've done...
I disagree with that. I believe that the reasonable particularity standard, which I think you're adverting to, is actually not a quantitative standard of proof, but as Judge Breyer recognizes in Spencer and other people have pointed out, I believe it is a qualitative level of specificity. So that foregone conclusion is the ultimate question for the standard of proof. We're submitting that subsidiary facts be found by preponderance. Preponderance is a standard of proof. Clear and convincing is a standard of proof. Reasonable particularity is a level of specificity. And it was originally designed to prevent the government from fishing for documents. Its persistence in the case law, I think, reflects one of the challenges we have mapping this paper-based document production doctrine to the newer world of digital evidence. And it doesn't map perfectly, and I think Gelfgott recognizes that in footnote 14, where it says the authenticity requirement doesn't really apply in the same way. And so,
But if you know only by clear and convincing evidence that he has access to the phone, and we compel him to put his thumb on the phone or to give you the password, then you know beyond a reasonable doubt that he has access to the phone.
we would, and I would just note that if it were a question of putting his thumb on it, we wouldn't be here, because that would be there would be no Fifth Amendment implication to that, no foregone conclusion doctrine. That would be simply a search warrant at a probable cause standard. It's one of the anomalies in the case law as it exists now. Biometrics, because they don't require that we compel anything from a defendant that even remotely looks like a testimonial implication.
Because it would not be testimonial, in other words.
That's correct. It would not be testimonial, and the Fifth Amendment in Article 12 would not apply. But the question of what we know after the fact, you don't need to focus on reasonable doubt, again, because we can't use that. The content that we're looking to use from the phone, if it's incriminating, we are going to try to use it. But the thing that stands between us and that content is not Article 12 or the Fifth Amendment. It's the Fourth Amendment in Article 14. We have already had to show probable cause that the contents of the phone is going to be potentially relevant to our investigation. Once we have that search warrant, if the phone is password protected, we might have to try to crack it or hack it. We might pursue a chip-off procedure, or we might do a GELFGAT motion. But at the end of any one of those avenues, only one of which has a Fifth Amendment implication, at the end of all of those is the content, because that's what stands between us and the content of the phone is the Fourth Amendment in Article 14. Once we've met that standard, if the defendant thinks that our scope is overbroad, his remedy is not anything to do with GELFGAT or the Fifth Amendment. It's a garden variety motion to suppress the search warrant, and especially in Massachusetts, where this court has already issued numerous decisions carefully delineating the limited scope and basis of cell phone searches. His privacy rights and the content are already protected. What we get from the GELFGAT motion is really just the limited testimony that he knows the passcode, which we're not interested in because we can't use it, and then the passcode itself, which is not entitled to any Fifth Amendment protection, but which we would also not be introducing into evidence because the circumstances of the act of production are not allowed to be put into evidence.
Well, I think that GELFGAT goes beyond that. It says, for example, the facts that would be conveyed by the defendant through his act of decryption, his ownership and control of the computers and their contents, knowledge of the fact of encryption, and knowledge of the encryption key already are known to the government, and that's a foregone conclusion. And in order to do that, he looked at the police investigation. Justice Spina, who wrote this for the majority, looked at the police investigation that had been conducted. And it was extensive about what was known already as to the documents.
And I think
and that's what happened here too. Who was the judge?
Justice Krupp, Your
Justice
Honor.
Krupp, I think did the same thing here. And on that one, you already have won. So I don't understand what the problem is.
I think that the phraseology in the GELFGAT standard of knowing of control of the phone and contents, and I think this is one of the points of the amicus brief filed by the Attorney General, was true in that case, but doesn't need to be true as a general formulation of the foregone conclusion doctrine, because again, you have to focus on what is the testimony that's inherent in the act of production. We're not asking him to do anything that would say that he knows the contents of the phone or controls the contents.
That's not true of what the GELFGAT requires.
How is it not true of what GELFGAT requires?
By tacit admissions.
Right, and that's why I think if you
Not just
focus...
tacit admissions as to what the ownership or control of the phone is, but the fact that he has control over the content of what is in the documents.
But again, I think that's why it's important to think about real-world scenarios. Is I could take... someone might know the passcode to their significant other's phone because they share it for GPS on long rides or it has photos of a shared vacation, but that doesn't mean, absent profound levels of trust issues, that they know every single thing in that phone, every text message.
If you get them to testify, is it really testimonial in the same way? Does the Fifth Amendment protect them?
Well, so that's what I was going to say, is if they turn out to be Bonnie and Clyde, and we can establish to a foregone conclusion that one of the partners in that relationship knows the passcode, even if he or she doesn't know all the content in the phone, yes, we could compel it.
Because that's not even a defendant.
But no, that's why I'm saying that if they were a co-defendant kind of team, if they're not a defendant, if the knowledge of the passcode isn't incriminating, there's no Fifth Amendment right whatsoever. We don't have to do a GELFGAT.
But if they're not being prosecuted, what is the problem with them giving over the information?
There wouldn't be.
That's right. It's only when somebody's a defendant.
It's only if there's a risk that the limited testimony that they know the passcode is incriminating.
Because
In this case, it's because that phone number was used on Backpage.com ads, so if you know the passcode, it would implicate you in the sexual trafficking scheme. But in a
why the
situation...
Fifth Amendment protects you.
That's why he has the limited Fifth Amendment protection in the limited fact that he knows the passcode. And I do want to go back to the choice of standards.
Can I before you leave that, the phrase that Justice Lang just read you, I take it you're saying that's not correct in this case, right?
I think that was a true characterization of the situation in GELFGAT, where he had said, I encrypted all this for my communications with the Russians, and you will never be able to get into it, and I use these computers. So the question of control and contents...
But wasn't it just getting access to the computer in GELFGAT too?
It was actually just getting him to enter the decryption code.
So why is... And here it's just entering the decryption, entering the passcode in the phone. Aren't those comparable acts?
They are. I think what I'm trying to suggest is that the breadth of the statement in GELFGAT wasn't significant in that case because no one was disputing whether or not he did or didn't know the contents, and so...
You want us to clarify that statement, right? You want us to fix that if you think that's an error.
You think GELFGAT was wrongly decided in that respect?
I don't think it was wrongly decided in that respect. I think that now that this question is put more precisely before the court, there's an opportunity to state the standard more precisely, consistent with the limited testimony inherent in the act of production, and not going beyond that to the contents of the phone that are protected by the Fourth Amendment or anything else.
Do you agree that there is a difference between the Commonwealth knowing something beyond a reasonable doubt and it knowing it by clear and convincing evidence?
I do. They are different standards.
I know they're different standards, but do you recognize that there could be arguable consequence to the Commonwealth knowing something with a greater degree of certainty?
It would be a higher initial burden for us to have to overcome at the Gelfgat motion, if I'm understanding your question.
But I guess the question is, isn't the whole purpose of the Gelfgat to avoid any need for a taint hearing? Because we're compelling the person to do something which is arguably incriminating, but we don't want to have a taint hearing. So to eliminate a taint hearing, we require the same level of proof that would be for a subsequent taint hearing, which is I already know it beyond a reasonable doubt. So there's no risk that I've learned anything or learned anything with a greater degree of certainty by having the compelled testimony.
I don't think that's actually the purpose of the Gelfgat motion. That is not, to my knowledge, present in any of the foregone conclusion cases. The purpose of a Gelfgat motion is to determine whether or not the defendant is adding anything to the information the government already knows, such that the question is whether it's testimony or surrender. And so if there's a determination, either by clear and convincing evidence or beyond a reasonable doubt, but whatever standard of proof you choose, that this isn't adding anything to the government's information, then the defendant has no right not to produce the evidence.
But the question is, I thought you just admitted that when the Commonwealth learns something knows something beyond a reasonable doubt, it has learned something beyond what it knew by a clear and convincing. That is, now it has additional information which has turned what was clear and convincing to beyond a reasonable doubt.
I do see that there is a gap there, but there's no consequence to the defendant in that because, again, we're not allowed to use that fact against the defendant. And when it comes down to just the single passcode issue, it kind of stops there. If he knows the passcode, he enters it. It's self-authenticating, and we now have the ability to execute the search warrant that we've previously obtained. And so no evidence.
Cause only,
I'm sorry?
on probable cause only.
On probable cause only, that's correct. And I think that that's another point worth discussing is that there's a suggestion, I think, in the CPCS briefing that you need the beyond a reasonable doubt standard because there are differences between Article 12 and the Fifth Amendment. And I would say this is not one of those carefully delineated situations where a departure is required. First of all, we are painting on a blank canvas, essentially. There is no established federal standard. But any kind of analogy to breathalyzer refusals or those situations, they're unavailing on multiple levels. And the first reason is because when a police officer makes a request to a suspect to perform a breathalyzer, he's seeking information that he doesn't have, the blood alcohol content. So whether or not we do it to a clear and convincing evidence standard or beyond a reasonable doubt, once we do a Gelfgat protocol, we're showing that to a relatively high level of certainty, we already have the information that we're seeking. But more importantly, what this court recognized in Commonwealth versus Delaney, and as I alluded to in the 16L letter I filed last week, is that once we have a search warrant or a court order, there is no catch-22 for a defendant. He no longer has a choice not to comply. And that's where I get back to Justice Lang's point about the probable cause showing. Under Article 12, it's sufficient if you have an underlying order made by probable cause that if a defendant refuses compliance with it, you can get an adverse inference against him at trial. So there's no real indication why clear and convincing, which although less rigorous than beyond a reasonable doubt is far more rigorous than probable cause, would be insufficient to protect the defendant's interests in getting the underlying order. I would also suggest that the CPCS focus on noncompliance in their amicus brief, it jumps ahead of the live issues in this case and the reported questions by presupposing noncompliance. And the focus on incarceration is the same. But if you actually take them on their issue and you think, well, down the line, if he refuses to comply, do we need beyond a reasonable doubt to protect the defendant's rights? And the answer is absolutely not.
Well, wait a second. If you don't know the passcode and you're just wrong, then you can't be compelled. I mean, you can be compelled, but you're just going to go to jail for a long time.
That's correct, and that's why I think Chief Justice Gantz's opinion in Burchell, which I again cited in the 16L, is the answer to that puzzle that CPCS throws out. It's not a puzzle at all. It's in the civil contempt standard, which would be Gelfgat doesn't result in detention. If there's noncompliance, there's going to be a separate civil contempt proceeding. And if the remedy there is incarceration, that's okay because under In re Burchell, as long as you can establish clear and convincing evidence of willful disobedience to the court order, including the ability to comply, that's already been determined to be a sufficient standard of proof to protect people's interests to impose incarceration for civil contempt.
And what if you see criminal contempt?
If the civil contempt is insufficient to get the defendant to cure and the paradigm shifts, then we would have to prove beyond a reasonable doubt before any sentence of incarceration is imposed. But here's what I think the most important point is. The underlying order in a civil contempt situation, in the garden variety case, is going to have been found by a preponderance of the evidence, as I believe it was in re Burchell. So there's no reason to suggest that if we even have to go to a civil contempt proceeding or criminal contempt, that the underlying order with which the defendant is not complying has to be found to a higher standard, because if it's probable cause, their noncompliance can have consequences. If it's preponderance of the evidence in the civil context, noncompliance can have incarceration consequences. So the protection is, as you found it to be, in the civil contempt proceeding, or if we need to shift and there's an actual sentence imposed, then we'd have the same standards we always do in a criminal case beyond a reasonable doubt.
I just have one question before your time's up. Oh, I guess it is up. Can you tell me how you're defining testimonial in this context?
I'm borrowing the definition that's been used throughout the foregone conclusion doctrine cases, going back to Fisher, and then through Hubble, and then as used by the circuit courts, and that it is communicating some statement of fact that would be incriminating to the defendant.
Okay.
And so,
And although doesn't Hubble and some of those other U.S. Supreme Court cases also suggest or say that if it leads to incriminating information, it can also be considered testimonial?
there's lines in the case law that if it's a link in the chain of evidence, that we would need to...
That you'd need to use, is that it? That you'd need to use it?
That would be that the defendant would have a Fifth Amendment right, even if it provides only a link. And so we are still complying with that because we're recognizing if it didn't provide even a link, again, there would be no Fifth Amendment protection. Here, the passcode could provide a link, and that's why he has Fifth Amendment
Are you saying
protection.
that the link has to be in the communication, a communication link, or just a link to the physical documents? I guess I'm kind of stuck on that.
So it has to be, the link has to come from the implicit testimonial communication, not from the contents of the documents themselves. If that were the case, we would never get over the foregone conclusion doctrine because the content is what the government is always really looking for. In the old document production cases, there's a piece of paper in a file cabinet somewhere, and it was created before the investigation, so there's no Fifth Amendment rights to it. We didn't compel the creation of it. But the second we say you have to bring it to us, if the target brings it, he's implicitly communicating that it exists, that he has possession of it, and that it's responsive to our requests and therefore authentic. That's the original paradigm. That's what he has protection in, that and only that he's implicitly conveying those concepts. The content of the piece of paper is ours and free to use. And that's why we don't worry then about a further taint, and that's why it's not derivative evidence in that way. Nothing derives from the statement of possession that we're looking to use. We're looking to use the content itself. Here, the content, to be clear, is the passcode. The content of the phone is protected by separate rights and separate procedures.
All right, thank you.
Thank you.
Mr. Reedy.
Morning, Your Honors. May it please the Court, James Reedy, who along with George Olson, represents the defendant appellee, Dennis Jones. I think it's best to start with whether the act of entering the passcode is testimonial. Quite clearly from this Court's decision in Gelfgat, it is. Quite clearly from the majority of courts that have considered this question, it is. I think the only court to say it is non-testimonial was State v. Stahl, which was an appellate court in Florida. And recently, another division of the appellate court, as of last week, I believe October 25th, disagreed with that determination and made a conclusion that entry of the passcode is testimonial. It was GQHL versus State. But Stahl is the only one to say that the entry of a passcode into a decrypted device, whether that's a phone or whether that's a computer, is non-testimonial. This court has held it as testimonial, quite correctly, I would suggest, as well as the vast majority of other courts that have dealt with this.
And would that change if we were using biometrics at all?
Biometrics are not considered testimonial.
Right.
I
So
think
what's, But what's the real difference? I mean, it's a, you know what I mean?
It poses a very interesting question as to whether courts need to reconsider whether physical attributes can be considered testimonial, given the way technology is moving towards biometrics as a means of security for information. And certainly there's a delicate balance to be had between the need for encryption, given cyber attacks and cybersecurity issues that have arisen in present day, and that balance between law enforcement's ability to access evidence. And I would suggest that that balance can be struck by requiring law enforcement to have more information about the material that is on the device it seeks to decrypt than the Commonwealth has presented here. In the majority of cases that have dealt with this issue, the government had significant information that the material it was seeking to produce by way of decryption was on the devices it was seeking and had specifics about that material. If we look at Spencer, which is something that the Commonwealth has addressed as clear and
But
convincing.
that's the Fourth Amendment issue. That's not, that's a whole separate, they've got a search warrant for the phone, right? So I don't understand why we're blending that analysis.
Well, Your Honor, so I would suggest that we're blending that analysis because in order for a defendant to assert that they have a Fourth Amendment right in a phone, they have to assert that they have a privacy right, that there's, and so it requires an assertion of possession or possession of the phone or the computer in order to.
You know, he possessed the phone, right? There was no doubt he possessed the phone.
Well, so, and this is an interesting part with what the Attorney General is talking about. The Attorney General is talking about usage of the phone or access to the phone. Now, the Commonwealth would suggest, well, look, if in relying on Professor Kerr, if there's a sister who has access to the phone, that would be enough to compel. I think there is something different between whether someone has access to a phone and whether they can assert a privacy right in the phone. The sister could not assert a privacy right in Professor Kerr's phone. She may know the passcode, but she doesn't have a privacy right. So there is a blend, I would suggest, when we're dealing with issues of decryption in the foregone conclusion analysis with both the Fourth Amendment and the Fifth Amendment as it concerns issues of privacy. And I would suggest that in order to address those concerns, having the state require more as to what are contained within the content of the phone is a necessary
I
prerequisite.
don't get that, because if I compel you to give me the PIN to your phone, all I'm compelling you to do is give me the PIN to your phone. It doesn't matter what its contents are.
To some extent, that is true. However, what the court has addressed when it has discussed foregone conclusion is what we're trying to prevent is a wide-ranging foray, a fishing expedition by the government. And that is absolutely, of course, developed with paper cases, and we're requiring a certain specificity for the documents that are being produced.
But that's Dorellis. That's all our cell phone cases have that.
I'm sorry?
That's all our cell phone cases. You have adequate protection in all our cell phone cases on the Rummagen argument.
There's adequate protection, assuming the defendant can assert a privacy right within the phone.
How is there a fishing expedition if the standard is to be able to show that the defendant has access and is able to open the phone? If that's what we're looking at, how can it be a fishing expedition?
I would suggest that that part of the reason that the foregone conclusion analysis is developed is to prevent someone from saying, prevent the government from saying simply someone has access to a document or information, that they are required to provide that document or information, and that the government can have a lesser standard of proof relative to what that document is. So I would suggest that perhaps the issue with the level of specificity that is required by the government is really something that is addressed towards why a beyond a reasonable doubt burden of proof is appropriate. Now, I understand that beyond a reasonable doubt deals with access to the phone, but at some point in time, that connection between the information that is sought and what the government can prove is the defendant's access to the phone are related. For example, if we look at Spencer, the defendant had traded images of child pornography with a particular individual. He had told that individual that the device was encrypted. They knew the device was encrypted for the purposes of protecting child pornography. It was the government had a much greater understanding of what was contained on that computer before it was able to provide able to meet that foregone conclusion standard.
But don't you need to be careful of what you wish for? Because if the standard is more than you must show that you know it's one thing to say you must prove beyond a reasonable doubt that the person has access to the phone. Mm-hmm. Once you begin to get into, no, you must prove beyond a reasonable doubt that not only the person has access to the phone, but that you know the contents of what's in the phone, then you're never going to have proof beyond a reasonable doubt at this stage in the investigation. So, which means we're probably not going to use proof beyond a reasonable doubt if you extend it to what is inside the phone as opposed to whether or not you know the PIN to the phone.
But wouldn't you know a lot about the phone here and what was in the phone by virtue of the text messages that were already seen,
You would know that
as Judge Krupp found?
there's certainly there can be an inference that was the text messages are contained within the phone. I would suggest that ultimately the question then becomes who is the author of those text messages. Obviously, the complainant says that that's Mr. Jones. There's nothing within the information provided by the government to indicate, I shouldn't say nothing. There's a lack of specificity in the government's
So you disagree with Judge Krupp's findings as to that?
I don't disagree with Judge Krupp's findings to that. I certainly agree with Judge Krupp's findings that the phone is connected to, let me say that. I think that the court can assume that Judge Krupp's findings are accurate. I don't want to get the cart before the horse and potentially waive any rights the defendant may have later on. There has been a motion to suppress her in this because there's an issue of the assertion of privacy in a phone that the defendant is currently maintaining. The Commonwealth has to prove beyond a reasonable doubt that he has access to and control of.
So if there was evidence here that we took as enough to show that he has control and possession of the phone and its contents, what would that be enough? I mean, here, it seems to me the fact that it was found on him. Mm-hmm. The complaining witness says that he used it repeatedly to contact not only her, but to get business to do the magazine and so forth and so on. It's hard to imagine how it is somebody who has control of the phone, whose phone is used for that purpose by him, couldn't have unlocked it. Because how could you use it without unlocking it?
So we're going beyond the scope of what's contained in the record, but you can use a phone without unlocking it. There are voice activation systems which allow someone to use a phone without locking it, that allow someone to use a phone to send texts, to make phone calls, to send emails without ever having PIN access to the phone.
But we're talking about reasonable inferences, right?
Agreed. No, absolutely.
I mean, the normal course is someone has a phone
So-
in their pocket and they use it, they know the password.
Remember, he had two phones in his pocket.
Right.
And it could be Professor Kerr's sister carrying around his phone at a party. That doesn't mean that she has
Could be a lot of
control
things. The question is whether there's an inference.
Agreed. So then the question becomes
But what do you say about the legal standard, though? Should we use clear and convincing? I know you want us to use beyond a reasonable doubt. Give us your best argument for beyond a reasonable doubt.
It's a testimonial statement. Article 12 routinely requires proof beyond a reasonable doubt for testimonial statements. I would suggest that it's similar to, it's in essence a compelled statement of sorts. It's an order from the court to enter a passcode into a phone.
Proof beyond a reasonable doubt of what?
I'm sorry, Your Honor?
Proof beyond a reasonable doubt of?
Proof beyond a reasonable doubt that the defendant has, ultimately, that the defendant has the passcode to the phone.
That's it, not the contents. If the Commonwealth proves beyond a reasonable doubt that your client knows the PIN, they get it.
That's what this court has held in Gelfgat. I have suggested in the brief that given the search warrant here, which is essentially the government saying we need to have access to the phone to determine who controls the phone, that the court may want to reconsider the extent to which the content is an element of that analysis.
Well, in Gelfgat, let me read it again. We said that the facts that would be conveyed by the defendant through his act of decryption, his ownership and control of the computers and their contents, knowledge of the fact of encryption, and knowledge of the encryption key already are known to the government, and thus are a foregone conclusion. So we're talking about all of those things in Gelfgat.
You are talking about all of those things in Gelfgat.
I thought you just said we were not.
Well, what you suggested in Gelfgat was, or at least let me
And
back up a
let
little
me
bit.
ask you another question to sort of follow it up.
Sure.
Do you think in Gelfgat we used implicitly used the beyond a reasonable doubt standard?
I think you did, because I think that proof in that case was certainly beyond a reasonable doubt. And I think if you look at the majority of cases, or all the cases at least cited by both parties as well as the amici in this case, that all of those cases would have satisfied proof beyond a reasonable doubt, for which the court found that the foregone conclusion exception had been met. I'd suggest the very nature of the words foregone conclusion suggests an extremely high bar. And I know there's been the suggestion in Professor Kerr's brief that, well, look, this is just pulling words out. Well, it's the name of the exception. I certainly don't think that this court would take the emergency exception to the Fourth Amendment and say, well, slight concern by the government could qualify as an emergency. An emergency is emergency.
But it's
we know
not-
what that word means.
But I'm confused by when you say Article 12 requires proof beyond a reasonable doubt for testimonial statements. We require proof beyond a reasonable doubt for elements. We don't require proof beyond a reasonable doubt for factual findings in general. So I'm confused by that.
I think that was, let me sort of correct my testimonial. I should say voluntary. The voluntariness issue is proof beyond a reasonable doubt. In the course,
But that's an element of the offense. This isn't an element of the offense, right?
no, it's certainly not. However, there is a required finding by the court that a statement is, assuming it's a live issue, that a statement is voluntary beyond a reasonable doubt before that testimony is allowed by a defendant, before that statement is allowed before the court. Now, I understand that given this court's holding in Gelfgat, quite rightfully, that the act of production in and of itself is not something that is admitted trial. But to get back to Justice Gantz's point to some degree relative to immunity, the fruits of that statement are, or that testimonial act are allowed to be introduced to trial. And this court has held previously, as cited in the brief, in the appellee's brief, that if the Commonwealth is going to use the fruits of a defendant's statement, it still must prove that that statement is voluntary before it can be allowed to use the fruits of that statement.
Was there any testimony taken
None.
with regard to this?
None.
So we stand in the same position as the judge.
You do. So this court suggested, I think it was footnote 11 in Gelfgat, that it described this as a discovery motion and mixed questions of law and fact, which I would suggest that ultimately becomes or to be taken de novo. I think the question of a judge's discretion presented in this case deals with the universe of evidence to be considered. And I would suggest, as I did in the brief, that the judge Judge Krupp was quite right in denying the Commonwealth's motion to add additional evidence before the court. And I'd suggest that the only evidence that is relevant to this court's decision, because that was not an abuse of discretion, was the evidence adduced by the Commonwealth in its first and then
Why is
separate
that?
motion.
I mean, the Commonwealth can seek a search warrant and get turned down and come back with more evidence, and we accept it. We don't say, no, you should have done it the first time. Why can't the Commonwealth keep coming back and saying the proof we failed to have before we now have?
Well, two reasons. I think first, the search warrant application is a non-adversarial proceeding. Once the Commonwealth proceeds by way of a motion and a court order, the rules of criminal procedure apply. The Commonwealth agreed with that when it filed its original motion to reconsider.
It's a denial without prejudice.
It absolutely can be denied without prejudice, but it's up to the judge's discretion as to whether it's going to allow that motion to be brought back again. And here, the question is, did Justice Krupp act in a way outside the norm when he denied the Commonwealth to bring back the motion for substantial justice when, and I think this is an important point, when the Commonwealth readily admitted that there are multiple ways by which it can access this information. not only through the chip-off procedure, but during oral argument on this particular motion, on page 20 of the transcript, the Commonwealth said, we have multiple ways, including this Gelfcat motion, by which to access the phone. Most of those ways do not involve us coming back to the court. So certainly Justice Krupp could say, in his discretion, you've come back to me late. You've produced all this information that you could have produced at the time. We are now a year since arrest. We are 6 months since your motion. And you are telling me that you have multiple ways to access the information on this phone. But you want to use this Gelfcat motion, and you want to use a taint team, and you want to go through this entire procedure of having, that involve multiple steps to have access to this, when you can do it without it.
So,
I would suggest that's not an abuse of discretion.
so say it's early in an investigation in a rape case, and the Commonwealth is seeking a buccal swab for DNA.
Yes.
And the affidavit at that stage is just not enough to obtain it. So 6 months later, child rape case, they want the DNA. The evidence is developed, the investigation is continued, and now the affidavit is enough to get the buccal swab. The judge can say, in his or her discretion, no, you can't have that evidence because you already tried once and didn't get it?
I would suggest that in that instance, it would be an abuse of discretion because substantial justice would require the Commonwealth to have access to that information because it's a buccal swab. The idea of the Commonwealth having multiple access to that DNA is, certainly could they follow a defendant around and swab a Coke bottle? Absolutely. But is that something that is minimally invasive? Yes. Is that something that the Commonwealth doesn't readily admit? Look, we have multiple ways to do this and we can do it tomorrow, but we just want the buccal swab? I'd suggest that that wouldn't fit within substantial justice. Now, obviously, if it's a grand jury issue and they're going before the court, and it's not simply a subpoena and a motion to compel, certainly Rule 13A5 has its place. But I think that a judge's decision to deny a buccal swab in that instance would be an abuse of discretion hinging on the substantial justice piece. And I would suggest here, where you have, and part of that buccal swab analysis I would suggest is the defendant's rights relative to that are limited. As we've discussed relative to biometrics, there is no right of the defendant to refuse a buccal swab other than to say that the Commonwealth has a met probable cause. Here, the defendant has a right to assert, that being the Fifth Amendment right. And if the Commonwealth, by its own admissions, has readily available other means of obtaining that information, that the denial is not an abuse of discretion relative to substantial justice. The substantial justice does not require the Commonwealth to come back and be allowed to have, as Justice Krupp called it, a third bite at the apple.
But it could, if the judge wanted to.
Absolutely. I certainly wouldn't suggest that if Judge Krupp made that decision, that wouldn't be, that I could come up here and say, look, the judge abused his discretion in doing so. But I think simply because a judge can make the opposite decision, and in both instances, not abuse his or her discretion.
You're not arguing that the judge, this reasonable particularity standard is correct, are you? Or because he
No,
doesn't.
so-
He doesn't. You want the beyond the reasonable doubt standard. The Commonwealth, I can't remember if they're clear, convincing, or reasonable preponderance, but no one thinks this particularity, reasonable particularity, is correct, do they? Do we have to do this over even regardless of this?
I would, well, if I could answer that question in multiple parts.
Yeah, no, I just reread the decision just a second ago, and it's all about reasonable
It is.
particularity.
It is. And in good candor, I believe the defendant's position below was that reasonable particularity was the standard. I think that, and to some extent, I agree with the Commonwealth. The reasonable particularity standard arose within document production cases. I think what I've tried to argue, perhaps not as successfully as I would have imagined, that reasonable particularity standard still has some sort of role in encryption cases. And that reasonable particularity standard still has some sort of role in the government being able to demonstrate the content of the particular encrypted material. So I would agree that reasonable particularity doesn't make sense as a burden of proof standard. There's nothing for what that that could mean.
And yet more circuit courts are adopting it.
More and more circuit courts are adopting it. It's an interesting conundrum, but I might suggest that when they say reasonable particularity, they ultimately mean proof beyond a reasonable doubt, given the facts, but they certainly haven't said that. Most have discussed reasonable particularity and have defined it in different ways, but the end result, if you look at the cases, really tends to be proof beyond a reasonable doubt, I would suggest. Soviet State, which is an Indiana case, followed reasonable particularity, but I think really defined it almost as beyond a reasonable doubt. But to get back to Justice Kafka's point relative to this particular case, I think that this court can look at what the Commonwealth produced, assuming whatever universe of evidence this court decides relative to that first issue. And I think this court can come to a conclusion, because there was no testimony involved, that the Commonwealth did or did not meet that standard, because it's a de novo review of fact and law.
So we can look at the facts and apply the correct standard, and you say affirm this, I guess.
I think you can.
Yeah.
I don't think it's, given the fact that there wasn't evidence adduced, and I think that there's, assuming that there are, if there are questions that the court believes that are appropriate to be answered that weren't addressed below, then obviously it should be sent back for addressing those particular facts and applying the appropriate standard.
So you don't think we should do it? You think we should send it back to have Judge Krupp do it again?
I think you should affirm it.
But
And I think if you do send it back, I think then it comes back to Justice Krupp based upon,
and we don't do it ourselves?
you can. And that's why I think you should, I think ultimately, look, this court had said, as they said in Gelfgat, it's a question of mixed law and fact. There's no testimony, there's no independent credibility information that can be assessed. I know Justice Krupp assessed credibility at some point, but I would suggest that was simply based on
Yes, he assessed the complaining witness's
he
credibility.
did, but not with respect to testimony at trial. He assessed it with respect to, look, you're saying that that both Jones and McNeil were using the phone at the same time, but then Jones and McNeil are in different states. So I think he has an ability to assess based upon the evidence before him, but that evidence isn't something that is not before the court. In other words, part of the assessment of credibility relative to trial testimony is the judges in the room. And there are certain factors and certain things which they assess, which this court, just by means of the record before us, cannot do. Here, that record is entirely before the court, and I suggest it's a de novo review based upon footnote 11 of Gelfgat.
So if we were to do a de novo review, and again, I don't know that we will, if we were to say the question before us is, do the affidavits demonstrate beyond a reasonable doubt that your client knows the PIN? Tell us why the answer to that question is no. Tell us why the Commonwealth has failed to meet its burden, assuming it is the burden, of proving beyond a reasonable doubt that the defendant knows this PIN, based on the affidavits it has presented.
I think perhaps my best answer to this question is to, and the court will tell me if this is the best route, is I think the Commonwealth is, quite frankly, I think the Commonwealth is close. There are additional pieces of information which are needed. I think if the complainant had said, look, I've seen the defendant use the phone, it's a black LG phone, or meets the description of what the phone is here, that, with the universe of evidence, might be enough. If the defendant had certainly made a statement that that is my phone, that may be enough. One of the major factors here that has never been answered, because it was just a statement that was sort of left out in the ether, was the Commonwealth statement that multiple people have access to the phone. But we think that Jones controls the phone because, in our experience, pimps control the phone, and we've concluded that he's a pimp.
Well, also, as just mentioned in another context, McNeil was not with 7119 when 7119 was used on certain occasions.
But neither was what they've termed as Jones' personal phone with the 7119 number on other occasions. They said sometimes it's there and sometimes it's not.
So the multiple users are only two, right?
So that's an open question. The Commonwealth simply said multiple people have access to the phone. believe it's paragraph 52 of Detective McManus's affidavit submitted in the December motion. They never identify what that universe is. And what I suggested in the brief was certainly if it was two, that the Commonwealth would have said it's McNeil and Jones. There is a third person that's involved in this, which they identified as Aunt Annie way back in the original when this whole enterprise started, according to the complainant. So it's there's nothing from the Commonwealth's evidence that universe is limited to two people. And I think that's enough of an open question that the Commonwealth needed to answer with additional evidence.
Okay, thank you.
Thank you, Your Honor.